What's up, y'all? This is Jeff with another legal video about the Las Vegas Bellagio shooting. Now, the prosecution is getting everything lined up right now. I want to kind of go over a few things of why the prosecutor chose open murder versus classifying exactly which type of murder it was, because there's a reason for why they're doing it. They really want this case to stick. They want to make sure they can get an indictment. They do not want to let this slide. It's going to be a stain on Las Vegas, a stain on the Strip, a stain on everybody involved if this case slips out of their hand. There could be no technicalities that he gets off on. Manny cannot walk free on that. He cannot get off based on, a defense that everybody knows he's trying to use, self-defense. It's not going to happen. But there are other levels of defense that his defense attorney might choose based on how the prosecutors have now set this up as open murder. Let's go over what open murder is first. In Nevada, open murder is not a specific crime, but rather a prosecutorial strategy. It refers to a situation where a prosecutor charges a defendant with all possible degrees of homicide for a single killing. This includes first-degree murder, second-degree murder, voluntary manslaughter, and involuntary manslaughter. Essentially, the jury or judge then decides which level of homicide the defendant is responsible for based on the evidence presented. First-degree murder usually involves premeditation, deliberation, or is committed during the first commission of certain felonies. First-degree murder usually involves premeditation, deliberation, or is committed during the commission of certain felonies. Second-degree murder, all over types of murder that don't fit the definition of first degree. Voluntary manslaughter, a killing that occurs in the heat of passion without premeditation. Involuntary manslaughter, a killing that results from criminal negligence or recklessness. So those are all the phases of murder. So you got your first degree all the way down to your involuntary manslaughter. When you choose open, you can go for any of those. The prosecution can say, you know what, we might not be able to stick first. We may not be able to stick second, but we can stick involuntary. We can stick with voluntary. They always want to leave themselves some leverage based on the evidence that's rolling out. Now, if they come straight out the gate and charge first-degree murder, but then evidence rolls out that says it's not first-degree murder, they just shoot themselves in the foot. So they say open murder. It's a much bigger playing field they can deal with now. Prosecutorial flexibility. It allows prosecutors to present evidence of supporting varying degrees of homicide without committing to a single theory. Jury empowerment. The jury or judge in bench trials has more discretion in determining the appropriate level of culpability based on the evidence presented. Defense challenges. Defendants and their attorneys must prepare to defend against multiple charges simultaneously, which could be more complex and resource intensive. Potential for compromise verdicts. Juries may be more likely to reach a consensus on a lesser included offense if they cannot agree on a most serious charge. So you see all the reasons why prosecution would do this. They want to put like the biggest playing field out there and say, now you got to bring like a full 12 players out. You got to bring 11 players out. You got to bring 7 players out. You need a full field now. So if they went with just one level of defense, then the defense could say, oh, we could just attack that with this evidence. But if you have open murder, it's more time consuming. It's more labor intensive because now you got to cover more bases with open murder because you don't know which way the prosecution is coming. That's why it's a good way to charge with open murder. Homicide defenses. Depending on a specific case, potential defenses to murder and or manslaughter charges include you acted in self-defense or the defense of others, you were falsely accused, you were wrongly picked out of a lineup, the incident was an accident, you were insane, or the police committed misconduct such as by coercing your confession. Now we know from looking at this case, everything's on video. There is no coercing a confession. So that's right out the window right there. We also know there's no self-defense because we didn't see anything at the current state that was going after Manny. Nobody went after him. Bubbly didn't go after him. Finny didn't go after him. Anybody around, nobody went after Manny. So self-defense goes out the window as well. He doesn't have a lot, but he has insanity. Now, insanity is a defense that many people use in order to get off the hook of saying, you know what, I'll plead guilty to a lesser charge, or I'll plead guilty to something completely different because I wasn't in the right state of mind. The problem is that so many people are online right now saying he was out of his mind. He's mentally ill. He's insane. He's not right in the head. That's all building up the case for the defense. That's why I tell people, if you really feel that way and you're saying, well, he's been off his rocker for X amount of months. He's been acting like this. He's been out of his mind. He's been, mentally insane. He's been saying the craziest stuff. You're building a case for the defense when you do this. You might be thinking, oh, we're really beating him up and we're bashing him and saying all this bad stuff about him, making him look so bad. You're giving the defense ammunition. With open murder, you don't know which way it's going to go. You're giving them an insanity defense. You might not want to do that. A temporary insanity plea is a criminal defense that argues the defendant was briefly insane during a crime and therefore couldn't understand their actions. It's often used to contest the mens rea, or specific intent required for certain crimes. The defense originated in the 19th century and was first successfully used in 1859. Arguments. The defense claims the defendant was unable to understand the wrongfulness of their actions due to a severe mental illness or defect. It's most often successful when the defendant claims they were compelled by horror, revenge, or tragic circumstances rather than mental illness. Proof. A difficulty with this defense is proof, as any psychiatric examination occurs after the crime. The only evidence is the defendant's conduct before or after the crime. Intoxication. Intoxication can be a valid reason for this defense, but extreme emotions like anger and passion are not accepted in some states. Outcome. Juries and judges often consider mitigating circumstances and praiseworthy motives and may not impose the full penalty. However, most defendants will end up with some form of prison sentence. So for everybody out there arguing that, hey, there might be an insanity plea, that basically outlines it's very hard to prove insanity. It's even more hard to prove that you went insane and now you're sane all of a sudden. You're still going to get some form of prison sentence, whether it's life in prison, 10 years, 15 years, you don't quite know yet. The judge and the jury, they're the ones who have to deal with it in an open murder case. They're going to determine which level it is. The defense says, okay, since we're at that level, this is our plea. We already know right off the bat. You're out of your mind if you think self-defense is going to work. Out of your mind. But that may be part of the insanity. Think about it. If you do this on camera, cold blood, right in front of everybody, then you turn around and say, oh, that was self-defense. You must be crazy. There's a little bit of crazy involved in to think that that's even going to work. There's got to be some crazy involved in that. And then you got everybody online saying you're crazy, you're mentally ill, he's off. I mean, the case is building itself right in front of them. The defense is building itself. A lot of people are helping the defense by saying he's crazy, he's mentally ill. And then they go say, he trying to say it's self-defense. Man, he's out his damn mind. Maybe that's the play the whole time, is to appear to be out your damn mind. Now, what I won't do is rehash over the entire case right here. I got videos already for that. If you look in my crime and legal playlist, you can start from the very first video I did all the way up to the last video I did to kind of gist on how this case have been unraveling. So many layers to it. So many rocks have been unturned right now. We already know that Manny may have committed the murder. He will be in jail for the rest of his life. No doubt. I believe. No doubt. Finny and Bubbly, they're buried right now. Rest in peace. They have a lot of family, a lot of friends that are hurting right now. We can't bring them back. There's nothing we can do. But we can get justice for them. That's what the DA wants. That's what the families want. That's what the prosecution wants. They want justice. So as they turn over rocks, there will be different levels of people involved in this, I believe. And I've got videos stating how I believe other people could be implicated and what turned out to be a double homicide on the Las Vegas Strip. Now, if you want to see what I say, open those videos, take a look. You can hear my take on it.